Welcome to our program. I'm John Baker of Lancaster, Lebanon, IU13. Those of you watching this video have already completed your mandatory 3-hour training relating to Act 126 prior to January the 1st of 2015. Act 126 will continue to update through its 5-year cycle, and we are committed to keeping all school employees and their contractors up to date as these changes occur. This program is not meant to replace your original training, but simply inform you of the sometimes minor and technical but very important changes in Act 126. Who is a mandatory reporter? Act 126 now includes in its definition 14 new categories. Among the 14 new categories, you will find private school staff, university and college staff, clergymen and spiritual leaders, employees of social service agencies, law enforcement officers, public library employees, attorneys, foster parents, leaders of any public or private youth, educational, or athletic organization, emergency services staff who are certified by the Pennsylvania Department of Health. A key point to remember is that if a person does not come into contact with children, whether they are an employee or volunteer, they are not defined as a mandatory reporter. As a mandatory reporter, you are required to be familiar with the expanded definition of child abuse. Sexual or romantic invitations, dating or soliciting dates, engaging in sexualized or romantic dialogue, making sexually suggestive comments, self-disclosure or physical exposure of a sexual, romantic, or erotic nature, any sexual, indecent, romantic, or erotic contact with a child or student. As part of these expanded definitions are 3 new layers of culpability: recklessly endangering, knowingly endangering, and intentionally endangering a child. We must remember that any act of child abuse is a serious matter and has serious consequences. An important new issue to discuss in relation to reporting is the concept of good faith. A reporter can assume that their involvement in the process will be in good faith. This simply means that your statements you make are truthful without malicious intent and based on the requirements you learned from professional or personal experience or your training. This good faith extends through your initial report all the way to the conclusion of the investigation. And while operating under good faith, you are immune from both civil and criminal action. You do not have to fear any repercussions for your due diligence. You are the first line of defense in recognizing and reporting suspected child abuse, and no one is more important in this process. The law has included even more protections for the reporter by making it illegal for anyone, including your employer, to attempt to obstruct, impede, impair, or interfere in any way with a person who wishes to file a child abuse report. If this happens to you or anyone you know, make sure that the local law enforcement agency is contacted immediately. It is difficult to imagine why anyone would fail to report suspected child abuse. But understand, if you do, there are serious consequences. Depending on the severity of the child abuse, you as a person who failed to simply report it can be charged with failure to report and be convicted of a crime ranging from a felony of the first degree, which has a 7-year prison sentence and up to a $15,000 fine, to a misdemeanor of the second degree, which has a 2-year prison sentence and a $5,000 fine. These are serious crimes with serious consequences for you and your family. With our new understanding of the definition of mandated reporter, the types of events we need to report, and the consequences for failure to report, let's look at how to report. The most important change in the updated law is the requirement that you must report what you saw on your own. This means it is your responsibility, not a coworker, a supervisor, or your employer. And the state has made it easy with the creation of the Childline hotline. You simply contact 1-800-932-0313. This hotline is available 24 hours a day and is as easy as dialing the number. Internet access or passwords are not required. If you prefer, there is an online method for filing, but all reporters are encouraged to make the call. Childline needs to hear this information firsthand from the person who suspects abuse as soon as that suspicion exists. You're allowed to discuss your suspicions with your coworkers in deciding if you need to call, but once you believe abuse is possible, you must call. You will find that Childline is extremely supportive and sensitive to the situation. You will not be made to feel foolish or regret your decision to make this call. Calling Childline to report can be triggered by any of the following circumstances. Direct observation of the child. This may happen in the course of employment or through some regularly scheduled activity. Responsibility for the child. The mandated reporter is responsible for the supervision, training, or care of the child. Credible second-hand information. The mandated reporter gets information that a specific child is a victim of child abuse. Confession by the abuser. The disclosure must come from an individual 14 years of age or older, and note that they have committed child abuse. Please remember that these reporting requirements apply even if you do not know the name of the abuser. Once you determine a call to Childline is warranted, gather all the information you can so it's readily available when you make your report. The name and address of the child involved. The name and address of the child's parents or guardians. Where the suspected abuse took place. The age and sex of the subjects of the report. The nature and extent of the suspected abuse, and any evidence of prior abuse to the subject or a sibling. The name and relationship for each person responsible for causing the suspected abuse, if known. Family composition. The source of the report. The name, telephone number, email address of the person making the report. And you should also note the best way to contact this reporter. Actions taken by the person making the report, to include pictures, removal or keeping of the child, or getting medical attention. Be prepared to share copies of all materials of evidentiary value with the Department of Public Welfare or your local children and youth agency. And while having all of this information is optimal, it should not delay you in calling Childline. They would much rather receive partial information in a timely manner so that they can make sure that the child is safe than full information and it's too late to help. The updated Act includes several additional issues. Time limits have been removed for filing a complaint with the Pennsylvania Department of Education. Previously, interested parties had to file a complaint with PDE within 1 year of the misconduct or its discovery. It would be 5 years after a student turned 18 in cases of sexual abuse or exploitation. Filed complaints are now subject to penalties for a violation of the Pennsylvania Crimes Code for unsworn falsification to authorities. If a complainant makes any written false statements, which he or she does not believe to be true, with the intent to mislead a public servant in the performing of their official function, that complainant commits a misdemeanor violation. Consent is no longer a defense in regards to sexual exploitation, sexual misconduct, or exploitation. Previously, consent was used as a defense regarding some types of sexual misconduct between an employee and a student, especially when the investigation revealed that the initiator of the conduct was in fact the student. Specific protection is provided for reports made in good faith. Good faith being sincere, honest intention or belief according to legal standards. Any educator who becomes aware of any action, inaction, or conduct constituting sexual abuse, exploitation, or sexual misconduct must file a report with the Pennsylvania Department of Education, the chief school administrator, and his or her immediate supervisor within 15 days of the discovery of the misconduct. Previously, there was no formal reporting requirement regarding the misconduct of others. Any educator arrested for and convicted of a crime listed in Section 111E, subsection F of the Public School Code must report the arrest or conviction to the school within 72 hours. Pennsylvania Department of Education may investigate any and all allegations of misconduct in a complaint and may act on any other misconduct discovered in the course of the investigation. Thus, allegations may continue to grow as more infractions come to light during an investigation. Previously, the law was silent regarding new misconduct discovered during an investigation. Our final section applies to professional educators that fall under the jurisdiction of the Professional Educators Discipline Act and the Professional Standards and Practices Commission. There are a couple things you need to know. The Act and the Commission now have expanded disciplinary jurisdiction to include private academic certificate holders and contractors providing direct educational services to public school students. Previously, these areas were not covered by the Commission's jurisdiction. PDE must also revoke the certificate or employment eligibility of any educator named in a founded child abuse report as a perpetrator of abuse or a person responsible for abuse. A founded report is a child abuse report made under the law if there has been any judicial adjudication based on a finding that a child who is a subject of the report has been abused, including the entry of a plea of guilty, nol contendere, or a finding of guilt to a criminal charge involving the same factual circumstances involved in the allegation of child abuse. The Commission has the authority to order rehabilitation opportunities in conjunction with or as an alternative to discipline and to impose fees, fines, and costs to be paid into a restricted account for disciplinary enforcement. Prior to the change, the Commission had no power to provide for rehabilitative services nor to impose fees or fines. Keep in mind that some aspects of post-event discipline and activities still remain with the school or district, such as reinstatement. The Commission has the complete authority to alter a hearing officer's recommendations or reopen the processes for additional evidence within 60 days of the mailing of the proposed report, even if no exceptions are filed. Prior to this change, a hearing officer's recommendations became final after 30 days if neither the PDE nor educator filed exceptions with the Commission. Changes for school administrators center on requirements for reporting and generally reducing the number of days to file a report. Administrators must now report all educators who have been provided a notice of intent to dismiss from employment within 15 days of the notice. This has been reduced from 30 days. File a report for all resignations and separations from employment after allegations of misconduct have arisen within 15 days of the resignation and separation. This has also been reduced from 30 days. Report all allegations of misconduct or sexual abuse or exploitation within 15 days of the discovery of the allegation. Report information constituting reasonable cause to suspect that an educator has caused injury to a student as a result of negligence or malice within 15 days of receipt of the information. You should note that reasonable cause is an undefined standard, which is something in the vicinity of more than a hunch, but does not require absolute certainty of proof. Experts say, when in doubt, report it. Report any educator who has been charged with or convicted of a crime graded as a misdemeanor or felony within 15 days of learning of the charge or conviction. And this has been reduced from 60 days. Report any educator who is the subject of a child abuse report filed by the school within 15 days of filing the report. And this has also been reduced from 60 days. Schools are also prohibited from entering into any confidentiality or other agreements that would possibly interfere with the mandatory reporting. A confidentiality agreement or non-disclosure agreement is a legal document between at least two parties that outlines confidential materials, knowledge, or information that parties wish to share with one another for certain purposes, but wish to restrict access to or by other third parties. All reports must include an inventory of all information and evidence in possession of the school at the time of the report. Thanks for joining us. If you have additional questions about these updates, don't hesitate to contact your school administration or your employer, your local children and youth agency, or go to the Pennsylvania Department of Education or the Department of Public Welfare's websites for more information.